Okay, I want to introduce ourselves. This is Don B., the taxman and a business advisor and a enrolled agent. And this is Franklin Riddell, an enrolled agent who knows a lot about trust. And so today's subject is, what should a person look for when they have a relative or friend and they are in charge of their affairs? So I'm just going to show how to get a hold of Frank right here, and myself as well. There's my advertising. But more than that, we're concerned about the fact that you do a successful job, because there's a lot of liability involved when you assume being in charge of a trust. So Frank, what should a person look for when a relative or friend passes away and you're in charge?
A good EA that understands what the rules and is working with estates and trusts. And the person responsible needs to have read the trust instrument and develop some questions to ask that professional so that he can still remain in charge himself.
Yeah, that's so important to find the right person, and most of the time, enrolled agents have connections. You do a lot of connections with attorneys, and so you can push them to the right attorney if they need that service too. That's why they should look for a good enrolled agent.
That's true.
Right.
That's true.
Right. Okay, and Franklin, what should a deceased have done before they leave this world?
Well, before one should have, everyone needs to have a will and a power of attorney for finance, durable power of attorney for healthcare, or they're now called an advance directive. That's what the hospital will ask for when you get admitted. Those documents are essential. Now, the trust document itself is not always essential. That depends upon the size of the estate and the type of assets that you have in your estate. So the trust document is something that you can or cannot have it.
Yeah, that's true. That there are various instruments, documents you need depending on what the status of the estate that somebody passes away. And if somebody says, "Oh, I don't have an estate," everybody has an estate. Even a man that's walking the streets with no home to live on has an estate. I think people don't understand that.
Yeah, no, that's correct.
Yeah.
In fact, over my years of doing this, there were homeless people, in doing that would come. Their relatives would come and say, "Well, we need to have this taken care of. He's passed." And yes, he did have an estate, even though he was homeless.
Yeah, yeah. Okay, and once a person is in charge, finds those professionals, what else should happen, Franklin?
Well, you need to have a list of what the assets are.
Franklin, I want to stop and remind you that you said if you're in charge and there's a will or a trust, he needs to read that first.
That's correct.
You tell me that all the time.
Yeah. That is essential. And one of the ways that you can find if your professional is a good professional is to see whether or not he asks you for that trust and or will. And I don't mean just the part that you think, well, you only need part pages 15 and 60 because that's for the beneficiary. No. He needs to read the whole thing, and he needs to be competent enough to realize he needs to read the whole thing.
And I don't again, I want to emphasize the fact that once you assume the position of executor, there's a liability there, and you can be sued if you don't follow the trust.
Now let's carry that a little bit further than that. When you take on this responsibility, you stand in the shoes of the taxpayer. That means you then become the taxpayer as if he was still alive. So, and you also have a fiduciary responsibility to family members and other people who are interested in this estate. The fiduciary responsibility that you have is actually greater than the responsibility you have to yourself or for your own money. So it's at a higher level.
Responsibility.
the responsibility, that's
Right,
correct.
yeah.
I sort of like when people will say, well, what's a fiduciary? I think we are all fiduciaries in one way or another. If we're married, we're a fiduciary to our wives or our husbands, as the case may be. If we have children, we are fiduciary to them. It's a level of responsibility, and it's extremely important. And as Don has already said, it can lead to suits and for the breach of that responsibility. You can have to be concerned about conflicts of interest. If you have an interest in the property along with being a fiduciary, I mean, the decedent has, the other members of the group will say, why should we trust you? That interest, you might take that interest and make it more paramount than their interest, and you can't do that. So it's better to have someone who is working with it, who can truly be independent.
Yeah, that's so true. Okay, so let's go back and say, so Franklin, if a person's in charge, what should happen? And you're talking about the assets, if there's assets.
Okay, in looking at the assets, we have basically two types of assets. Those that pass by law, and those will pass because of the trust instrument or the will. By law, we're referring to IRAs and life insurance, annuities, joint tenancy, payable on death, things that have a beneficiary already named. Whereas real estate, that may pass to the wife, it may be passing to no one, because there is a usual way to name a beneficiary on real estate. And stocks and securities and things of that nature. Those items need to be titled. If there's a trust, they need to be titled in the trust, not outside the trust. The will and whatnot will go into probate when you get through with that work. They will then be in the new name of the beneficiary.
Right. Okay, and what kinds of assets are there, Franklin?
Well, as I was saying, that you have assets that pass by law. You have assets that may not have any beneficiaries at all, so that will go by the will of the trust. You may have some assets that need to have beneficiaries changed on them because the beneficiary passed away. That needed to be taken care of before this current demise.
Right.
It's so important that once a demise happens, you go back and review the assets that you have to change and see, well, do I still want this to go to my dead son or not?
Exactly.
You know,
Yeah.
that may seem obvious to you.
Yeah.
But at the same time, what you also want to have is two levels of beneficiaries. You may have your first level may be your wife, and your second level may be your children, as an example. Because it's always possible that the first level may have passed or will pass shortly, because the first level will probably be the same age level, whereas the next level will probably be younger, and there's a greater chance for them to be alive at the time of the passing. So leaving everybody at the same level tends to cause more problems than having two levels of beneficiaries.
Good idea. Okay, and let's talk quickly about, in short terms, about community property. You're not happy about community property.
Community property has several things about it. Actually, joint tenancy is what I'm really not happy about.
I'm sorry.
But we'll get to that in a minute. Community property has several points about it. First, you should be titling with community property with right of survivorship. Whether you're the husband or the wife, that protects you. With community property without right of survivorship, that means that you can independently give your property to somebody else besides your wife. She may not like that too well, but you have that privilege. Whereas if you said right of survivorship, she's going to be the survivor and she's going to get it automatically on the time of demise. And of course, it would work the same way the other way around.
Right.
Now, getting on to the one that I'm not least favorable to is joint tenancy, because there you only got one person passing it to, and that's the second person. If that person hasn't put another joint tenant on it, then it's going to go to probate regardless.
Right.
So many people like to use joint tenancy as a way to avoid probate, when it really doesn't. Another thing that's harmful there also is a tax angle. If it's husband and wife, and you may have heard of what they call a step-up in basis, meaning it's valued at the time of death, or revalued, I should say. The wife's, the survivor's portion does not get the step-up. Only the deceased person get a step-up.
But with community property,
Right.
both people, the deceased and the widowed both get their step up.
There's a full step-up
Right.
on the first to die for both halves
Right.
of the community property.
Big deal.
Now, there's one other point that needs to be brought out here. There are times when you've inherited property, by gift or by demise, however that happened, and you've decided, well, hey, I want this for, maybe the person you inherited it from has children, and you decide, well, it was his money, I'm going to use this money to raise his children with and put them through school. Well, and you decide to do that, all right, you get married, now you say, well, now how am I going to achieve it now, because I'm building community property now. Well, the way you do that is be sure that what is called separate property, that you've titled it that way, and you've kept it separate. You don't commingle it with the community property that's now being built with your new marriage. Or if you're already married, don't commingle it with your own property too, because the presumption upon demise is that everything is community. So one has to prove what portion is not. Well, the easiest way to do that is when you start, is keep it that way. And you set it up with its own checking account, with its own money, and you let it, sort of like a business, support itself. And that way, you're not mixing community with separate.
Great idea. Great idea. Okay, we've only mentioned real quickly that when does probate kick in?
Well, estates that are over 150,000, you can look forward to probate. Under 150,000, you don't need to worry too much about having to have probate.
But we recommend people have irrevocable trust so that they can avoid that probate.
Well, that's another interesting point, though. If you're expecting a lot of arguing and discussion about how things go, because there's different interests within the family, or there may be, the interest may be that blended families, that creates more of these types of activities. So in cases like that, sometimes it's better to go to probate than going to trust, because you'll have a judge overlooking it, which provides a greater fairness because he's independent. When you get into trust, you don't necessarily always have that benefit. So it does become more expensive in probate. It does take longer, but sometimes you decide, well, I'm going to have, knowing that, I still want it to go that way because John Doe over here is going to take it all, and Susie Cutie won't get anything.
Mm-hmm.
And the judge will protect her interest.
So, give me some good advice here in summing this up. What should a person look for again, Frank?
Well, he needs, as I said, many people will start, let's put this way, many people will start with their tax professional to look for the work simply because they don't want to pay the attorney. And I always refer people to good legal counsel. He is a very important part, and he should be used. But the tax professional has his need to accomplish certain things for you. The attorney has his. The attorney is maybe great in doing taking care of all the legal work, the retitling and filing things and et cetera, but they don't do taxes for the most part.
Yeah,
So you need both to make this a team.
okay,
You can't get along without one without the other.
all right. And we're gonna give them another tax tip, and that was about, it's the exclusion, Dick.
Yes,
Yeah,
if it's a time of demise and it's husband and wife, and they have a residence, and she wishes to sell it, you still can retain the $500,000 exemption up to 2 years after the demise, if that full exemption is needed.
right, and that starts, when the person passes away, that's the 2-year period.
That's right,
Yeah,
that's
it's
right.
not
It's not on a calendar
Not
year
a calendar
basis.
year basis.
It's on a 2 years from demise.
All right, finally, thank you so much, Frank, for your information. We try to keep this short so people don't get bored. If you need to get a hold of Frank, here's his information. Please contact him. He's been around doing this for many years as with the bank and now with himself, and so he has lots of experience. Personally, I refer all my clients that have a estate problem to Frank. But if it's a business question, please give me a call, and there's my advertisement. We look forward to giving you more information on YouTube. Thank you.